Who is the government?
Yes. For the state.
State, okay. You give them the valuation of the Vicky land. Already there is a judgment in Kosari's case. Okay. Valuation for Vicky land, not Salitoli land. Although the DC has given the valuation of Salitoli land, yes. They have proved with evidence and documents and neighboring witnesses that they had residences over there. So, Vicky land, along with the Solatium. All right?
My lord, it has been enhanced.
Huh? Yes, from Salitoli land to Bhiti land. They'll assess the valuation. And then if there is any, there is always a proceeding of contempt.
Item number 2025, Lordship of daily list. An adjournment for
Item number
25. I will inform Lordship and send out of send judgment, Lord.
'25 and '26.
Lordship.
Learned Counsel Mr. F. has prayed for adjournment. List the matter positively for hearing on date of the video. 15 July.
May I please, your lordship? It's a bail hearing. Day before yesterday, it was
As
left
this
over.
is a long pending matter, huh? List the matter positively for hearing on 15 July. As this is a long pending matter. Yes?
Yes, no, the day before yesterday, this matter was left over. So as we're mentioning it, bail application. No, well, it has been ejected by your lordship, so it has to be before your lordship.
Mention according to the roster, you'll have to mention before court number 3.
No, the bail application has been ejected by your lordship.
You'll have to mention before court according to the roster.
Maybe the Lord.
Just go through the roster, you'll understand.
My lord, there is an IA for. My lord, there is an IA for suspension of sentence, my lord. The matter was last listed on December 2024, my lord. My lord will accommodate me on any date on the next week, my lord. Deep level.
Which one? Which one?
My lord, 12th June.
Okay, no. What were you asking?
My lord, it is it's an IA for suspension of sentence, my lord.
Okay.
May I please, Lordship? Lordship, I beg to item number 16, Lordship. 16, Lordship, kindly adjourn for the day, Lordship. For 2 weeks. 60.
Learned Counsel Mr. Amit Sheikh.
Jadis Ahmed, Lordship.
Jadis Ahmed has prayed for adjournment.
Lordship, I'm ABR on behalf of
Is the
Jadis Ahmed.
matter on behalf of?
I'm S. Islam, Lordship, on behalf of Jadis Ahmed.
S. Islam. S. Islam, Vice, VIC Vice, Learned Counsel Mr.
Jadis Ahmed.
Jadis Ahmed has prayed for adjournment. List the matter on
After 2 weeks.
after 2 weeks.
Deeply obliged.
Please, your lordship.
Mm.
Lordship, I beg to mention for listing of a criminal petition. It was listed yesterday before your lordship. On Monday or Tuesday, your lordship.
Monday on Tuesday, Kundinaha. Criminal petition.
18 June.
May I please, sir? I beg to mention item 34, my lord.
Mm.
And this matter be taken after a week, my lord. It's a hearing column, my lord. 34. After a week, my lord.
Learned Counsel Mr. D. Bora. Criminal appeal.
My lord, it's criminal appeal.
Have you taken the consent of the other side?
My lord.
Huh?
I'll
With
inform
the
you.
consent of the other side has prayed for adjournment. List the matter. When do you want? After 1 week.
After 1 week.
After 1 week.
May it please, your lordship. No, it's regarding item number 27, hearing item, my lord. Matter may come up after a week, my lord.
Learned Counsel Mr. P.J. Pukon
For the appellant.
for the appellant has prayed for adjournment. List the matter on date of the video. Positively for hearing as this is a long pending case.
Yeah. What's up? May it please, your lordship. My lord, item number 13, my lord.
Mm.
With the consent of the other side, lordship, can it be taken after 2 weeks? 13.
Can be. Learned Counsel Mr.
PK Garodia.
P.K. Garodia with the consent of the other side has prayed for adjournment. List the matter after 2 weeks.
Lordship, a date may kindly be fixed.
Date the details.
Can it be, my lord, 26? What if there is an interim order?
Interim order shall remain in force till then.
All right.
Yeah, please, Lordship. Just with the concern of other side, I beg to mention item number 33 of daily list. And the matter may be adjourned.
That place, Your Honor, I'm appearing for the respondent number 1 in this case. My prayer is for fixing a date, Your Honor, as soon as the reopening of the
All
court
right,
after some
can be fixed. Learned Counsel, Mr.
Mr. M. Borough, Lordship.
Amboro,
Lordship.
is present for the appellant. Learned Counsel, Miss
P. Chaudhary.
B. Chaudhary is present.
Sorry, Your Honor.
You are representing
I'm
who?
appearing on behalf of Rahul Bot, our both. The respondent number 1.
His name is not in the cause list.
My name is not reflected.
Even R,
Sorry,
you are representing who?
our both.
His name is also not in the cause list.
DM Nath is
Okay. DM Nath's name is in the cause list. Vice Mr. DM Nath has prayed for adjournment.
No.
Vice Learned Counsel Mr. DM Nath has prayed for adjournment.
Your Honor, I'm not the respondent. I'm not praying for adjournment. Petitioner is praying for it. Appellant is praying for it.
Yes, yes. Is present for is present liquidated. Vice Mr. The Learned Counsel for the appellant has prayed for adjournment. List the matter on
15th or 17th of
No, can it be 17 July?
17 July.
17th. Oblige you.
My pleasure, Lordship. But I beg to mention agenda number 30, Lordship, 30. Lordship, may kindly adjourn this matter for today.
You've taken consent of the appellant.
Initially, my lord, they used to appear in this matter, but for few days, my lord, they are not appearing, my lord. We have lost the contact with them. my lord.
I didn't understand.
And initially, they used to appear in this matter, my lord, the other side, my lord.
Uh,
But for last few days, my lord, they are not appearing in this matter. my lord.
Continue.
30.
Just a moment. They have not appeared at all. So what to do now?
Lord, after the vacation, my lord.
And see, interim order is not continuing.
Yes.
Interim order is also not continuing. Since 5/5/2015, interim order has not been continued.
Yes.
So we'll inform the court. There's no interim order.
But interim order was there, Lordship. But interim order was there
I'll vacate it and I'll inform the court. There's no interim order.
after the vacation, my lord. After that. Till then, my
No. How can I stretch the interim order from 2015 to this is 2025? 5/5/2015, this is 5/5/2025. 10 years. What is this? This is 5/5, no? 5/6. What is this? Court has also not been apprised.
5/6, there will be some difficulty, my lord. Kindly, my lord, after that, immediately after reopening, my lord.
What is your name?
Zedas, on behalf of Mr. A.K. Fuyan.
Learned Counsel Mr. J. Das, on behalf of Learned Counsel Mr. A.K. Bhuiya, has prayed for adjournment. The record reveals that since 5/5/2015, the interim order has not been extended. List this matter positively for this for hearing.
Hearing, my lord.
Item number
30, 30, my lord.
uh, um, positively for hearing on the next date fixed, as this is a long pending matter, and the interim order has also not been extended since 5/5/2015. On failure of appearance of any of the parties, necessary order may be passed. The respondent state is represented by learned additional PP Mr. D.P. Goswami.
Mobilized.
Positively without fail
I'm mobilized.
for hearing.
May I please develop on? Lordship, I beg to mention item number 4, Lordship. Kindly pass over for the day, Lordship, because of some personal difficulty, Lordship.
Learned counsel Miss
N.A. Begum. Let's
N.A.
kindly
Begum has
list-
prayed for adjournment, list the matter on
after one.
after 1 week.
Obliged, Lordship.
May I please, Lordship, I beg to mention item number 15, Lordship. Can it be fixed on 10?
1/5/15, no?
Yes. Sorry, 10, Lordship.
Hmm?
10, 10.
10, item number 10.
Item number 15, can it be fixed on 10, Lordship?
Okay. Learned counsel Mr.
I, Sakma, on behalf of M.
I.
Sakma.
Sakma on behalf of learned counsel Mr. M. Ahmed
Yes.
has prayed for adjournment, list the matter up on 10,
Yes, Lord.
on 10 June.
Deeply blessed.
May appeal. Lordship, I beg to mention item number 36. My senior is some personal difficulty. Lordship, matter may be passed over for the date. Next week, Lordship, any date.
Learned counsel Mr.
H. Islam on behalf of B. Sinha.
H. Islam on behalf of learned counsel Mr. B. Sinha has prayed for adjournment, list the matter on 17 July.
May I please, your Lordship? I prefer listing of criminal evidence matters.
You hurry, you'll have to hurry.
May it please, your Lordship. This is a regular bail application, Madam. Under 483 of the BNSS, my here, my lord, our Lordship filed a order, my lord, it was rejected by your Lordship, my lord, around 1 year, 4 months back, my lord. That order, Lordship, kindly have a look at page 74, my lord.
NDPS.
NDPS, my lord. Now,
We'll call for the trial court records.
I leave it to your Lordship, only thing here, we have annexed everything, my lord. And
But-
2 years,
But isn't
5 months.
justified? It will be like resting everything on you.
I leave it to
We'll
your
call for
Lordship.
the trial court
My lord.
records. Call for the scan copies.
It is
of
from
the trial
Guwahati,
court.
my lord. Guwahati. it's-
Short it.
My lord.
Call for the scan copies of the trial court records with along with the scan copies of the CD. Please the matter on short date 11 June.
Much obliged.
May I please, Lordship? Revision petition, my lord, against order dated 2/5/2025, my lord. Here in this case, my lord, there is an agreement between the complainant and the petitioner, my lord.
Mm.
And before filing the complaint petition, my lord, he has paid me the, and
Can I?
before filing the complaint, my lord,
Mm.
petitioner paid, my lord, 40,000 and 90,000, my lord. As per DW1 and DW2, my lord, is 34.
You are the accused.
Yes, my lord.
How much did you borrow?
2 lakhs, my lord.
2 lakh.
Yeah.
And you have already paid how much?
20,000, 40,000 and 90,000.
40,000 and
And 90,000, 90.
1,30,000.
Yes, 1,30,000 before filing of the complaint petition. But that part not mentioned in the statement.
So what is the conviction?
Conviction is, my lord, 6 months plus 2,60,000.
2 lakh 60. What will be 20% of 2 lakh 60,000?
2,60,000, 20%. Two lakhs. 2 lakhs. Hold on. Get to- to- Hold on. 20. Hold on. Get 52,000.
You paid. Will stay.
At 52,000.
Deposit. Where do you want to deposit? In this registry or somewhere else?
My lord.
In the court, trial
In the court below. my lord.
court below. Third learned counsel, Mr. M. Ali, no?
A.M. Ahmed.
M. Ahmed.
A.M. Ahmed.
Item number?
2.
Okay. Learned counsel, Mr. A. Ahmed, for the petitioner Sarinul Islam, who has filed this application under section 438. Graduate section, this is revision, no?
Yes.
Graduate section 442 and 520 of the BNSS 2023, challenging the judgment and order dated 2/5/2025 passed by the learned session judge Chirag,
Iran.
in criminal appeal number 16 of 2025, upholding the judgment and order dated 27/2/2025 passed by the learned additional chief judicial magistrate, Chirang, in NICR case number 12 of 2023, whereby and whereunder the petitioner was convicted under section 138 of the NI Act and sentenced to pay a fine of rupees 2 lakh, fine of rupees sentenced to undergo simple imprisonment for 6 months and to pay a fine of rupees 2,60,000 with default stipulation. So it is submitted on behalf of the petitioner that prior to the institution of the complaint case, the petitioner had already paid rupees 1,30,000 on different dates. First up, he paid rupees 90,000, and on another date he paid rupees 40,000. No, to the
90,000.
Huh?
90,000 and
to
40,000.
the informant. Full stop. It is submitted that the petitioner has a good case of acquittal, as he had paid the major amount of money which is in dispute in this case. Full stop. I have considered the submissions at the bar. It appears that the operation of the impugned judgment and order in the aforementioned cases can be stayed, subject to the condition that the petitioner deposits an amount of rupees, deposits 20% of the fine amount before the learned trial court within 2 months from
2
today.
months. 2 months.
Within 2 months from today. Full stop. The operation of the judgment and order dated 2/5/2025 in connection with criminal appeal number 16 of 2025, and the judgment and order dated 27/2/2025 in connection with NICR case number 12 of 2023 is stayed until further orders. To stop. Meanwhile, call for the. Are you on bail?
Yes, I am on bail, my lord.
Then it's okay. Meanwhile, call for the trial court or call for the records of the aforementioned cases from the respective courts.
Yeah.
Issue notice to the respondent.
And petitioner in the meantime allowed to remain previous bail.
There is no prayer for previous bail.
That-
You are already on
Yes,
bail.
yes. Yes.
Call for the meanwhile issue notice to the respondents returnable within 4 weeks. List accordingly.
Obliged.
Respondent.
Worship, earlier this honorable court has granted bail to me, my lord. Thereafter, my lord, bail bond has submitted thrice, my lord. And every time bail bond rejected by the learned court below, saying that my lord surety is not satisfactory. My lord, kindly have a look first the High Court's order, my lord, page 37. And the operative part, my lord, will see page 40. Page 40, my lord.
No, so why don't you give a proper surety?
My lord, I have given, my lord, kindly see,
I'm
my lord,
supposed to check sureties here.
I have deposited cash amount also. That is also,
The cash amount they won't accept.
my lord, two surety, my lord, first,
Liable.
my lord, kindly see the impugn orders, my lord, it starts from page 42. My lord, the dissatisfaction, my lord, did not disclose, my lord. How can I satisfy, my lord? I have once rejected one, thereafter I submitted another bail bond, my lord. All are relatives of the petitioner, and sufficient amount of bail bond has submitted, my lord. Even then, my lord, the learned court below said, my lord, bail or not found satisfactory, my lord. What the petitioner can do, my lord. First, my lord, I have submitted bail bond on 30/04/2025, my lord. That is page 42. Again, my lord, on 3/5/2025, another bail lord, Akbar Ali, my lord, he submitted bail bond on behalf of accused person, the petitioner. And it is often that it is checked, verified, rejected on as bail or not found satisfactory.
Which
Same, my
one
lord.
of the order you are aggrieved?
These
By
three
which one
orders,
of the order?
these
Please
three
read-
orders, my
Please
lord.
read, show me the order. Show me the order.
This, it has these three orders.
These three orders, my lord, the 30, my lord, page 42 onwards, my
Oh, page 42 onwards.
lordship. And
Please,
lastly, my lord,
please let me read the order. Sit down. Let me read the order.
yes, ma'am.
This bail order was given by another bench,
Lordship,
not this bench, another
not this bench, my lord Justice Thakuria. Ma'am.
He's got a special type of format, and there he is writing, he or she who is the POSCO judge, whoever, he or she is writing that not satisfactory.
He has
There has to be some reasons why
Yes,
he or
yes.
she is not
He has
satisfied.
the right to, no, he has to be satisfied,
Ah.
otherwise. he has the
My
right
lord,
to-
that is why, my lord, I have come before this court. My lord, he has the learned judge, my lord, did not specify the reason why he dissatisfied, my lord. I'll have to satisfy, my lord, but the reason, my lord, that must be known to the,
Where is the law that he has to?
my lord, how can I
Exactly.
satisfy, my lord? Every time these conditions, my lord, I have fulfilled. The land documents, my lord, the three bail bond land documents, my lord, the revenue receipts.
Status of the case. Status because transfer of case without knowledge of the petitioner. Have you received a status report? We'll fix another date. Status report as called for is not received. Issue reminder, list the matter on. Short date. 12 June. 12 June. Of this. Item 6.
May I plead your lordship, my lord, the petitioner is before your lordship against the ex parte order by which, my lord, the petitioner has been directed to pay certain maintenance amount to the respondent, my lord. The order is at page 28, annexure 3, my lord. My lord, apparently this order has been passed ex parte against the petitioner, my lord. My lord, if your lordship comes to page 30, my lord, paragraph 2, my lord. Paragraph 2, by the order dated 29/5/2023, this case was kept filed due to the repeated absence of the petitioner before the court, and thereafter filed order dated 2/4/2024. On the prayer of the petitioner, the instant case was restored after considering the grounds shown. After the case was restored, the petitioner was directed for taking steps upon the opposite party through registered AD post, and after due service of the notice, the opposite party did not appear before this court, and accordingly filed order dated 29/7/2024, the instant case was allowed to proceed ex parte against the opposite party. So my basic contention is that, my lord, it has been passed, the petitioner never received the notice, my lord. So it has been passed ex parte against the petitioner. And otherwise, my lord, the petitioner, my lord, because, my lord, this court or the other courts have already held that the able person have to pay the maintenance. The petitioner, if your lordship comes to Annexure 4 at page 37, the petitioner is, my lord, he is in the welding profession for last about 20 years. Now he is suffering from, my lord, radiation cataract. And now he has been advised by the doctor that currently his vision can be corrected by photochromatic glasses. If he does this work for a longer duration, he can go blind. So now, my lord, the petitioner is not in a position to earn, my lord. He cannot continue with his avocation, my lord. He is completely dependent upon his father. And otherwise also, my lord, may I pray that the matter may be remanded back and fresh adjudication may be made with by considering all this material. And in the proceeding also, the petitioner, means the wife of the petitioner in the lower court case, my lord, she has not filed her affidavit in terms of Rajneesh versus Neha also, my lord. So, and since it has been passed ex parte against the petitioner, my lord,
Wife has not filed that
affidavit.
affidavit like Rajneesh versus Neha, okay?
Yes, my lord.
Because she was not
Yes,
aware
my
of
lord.
the
Anyways,
case.
my lord, because the petitioner has been advised by the doctor not to continue with his avocation of welding because he's suffering from radiation cataract.
Okay,
my
I'll
lord.
put it back.
Yes, my lord.
Allow her to contest.
Yes, my lord. That is my limited prayer, my lord.
Third learned counsel Mr. D.P. Bora for the naam nilikiba, petitioner naam to nilikiba. For the petitioner who has filed this application under section 528 of the BNWS 2023 with prayer for setting aside the judgment and order dated 6/11/2024 passed in FC within bracket criminal bracket close case number so and so. Most of the petitioner is aggrieved by the ex parte judgment. Petitioner aggrieved, oh no. It is submitted that the judgment has been passed ex parte in favor of the against the
Yes, my lord.
the petitioner is aggrieved by the ex parte judgment and order passed in favor of the respondent X. The petitioner was directed to pay monthly maintenance of rupees
10,000, my lord.
10,000,
Yes.
at rupees 5,000 each for the petitioner and her, for the respondent X and her minor daughter. Full stop. At rupees 5,000 likla no? At rupees 5,000 for the respondent and her minor daughter. Respondent X and her minor daughter. It is further submitted that the respondent has not submitted the affidavit as mandated by the guidelines laid down in Rajneesh versus Neha, RAJNESH, Rajneesh versus Neha and another reported in 2021 to SAC 324. The petitioner has also submitted Annexure 4 of the petition, which is a medical certificate,
Yes, my lord.
Relating to the petitioners I petitioners which shows that the petitioner is suffering from radiation cataract and has to and cannot continue his avocation as a
Welder.
welder, full stop. The petitioner is unable to pay the monthly maintenance to his wife and
Proper.
daughter, full stop. I have considered the submission. The petitioner is aggrieved as he was not afforded an opportunity to contest the proceeding and file his written statement. It appears that for the interest of justice, the petitioner has to be given an opportunity to contest the proceeding. Thereby, this case is remanded back and the petitioner is directed to appear before the learned trial court and contest the proceeding and file his WS and evidence. In terms of the above observation, this petition stands disposed of. Item 7.
My lord, that judgment and order may be set aside and quashed, my lord.
Oh, yes, yes.
Yes, my lord. 611.
Wait. Last sentence to agar period. Thereby remanded back thereby a judgment and order. Thereby the judgment and order dated 6/11/2024 in FC criminal case number 587 of 2022, impugned by the petitioner is hereby set aside.
Deeply obliged, my lord.
Lordship, I'm playing for passover of this matter.
Hmm?
Passover of the matter.
Time being.
Timing, Lordship.
May it please your lordship, my lord, I have come before your lordship. May it please your lordship, my lord, I am before your lordship for quashing of a charge sheet, FIR and charge sheet filed against the petitioner. The petitioner is a sub-inspector of police posted in Tamulpur. My lord, the allegation is this, that me with a informant on the promise to marry had consensual sexual relationship with her. And ultimately when
Video. Okay. Meanwhile, call for the scan copies of the child court records along with the scan copies of the CD.
Maluk, this charge sheet case, Maluk.
Yes.
Along with the city. Obvious, Maluk.
Cognizance by the learned lower court below, lordship. In this case, lordship, what has happened? The complainant was part of the negotiation process along with the petitioner hearing, and during that conversation, some general remarks were made, and based on that, he has now stated that it amounts to defamation, where the fact remains that the alleged statement is made to the person himself, not to any other third person. And second, lordship, there is contradiction in his statement, which is we have stated in complaint petition, the statement which has been recorded under section 200 CRPC, as well as the statement of the witness who is produced, which is recorded before the learned trial court, lordship. May I first take the lordship to the allegations made in the complaint petition, which is annexed as Annexure 1. Starting page 14, the relevant paragraphs will be paragraph 5 and 6 of the complaint petition.
Okay.
The issue is that the complainant was engaged by 3 of his clients, namely so-and-so, to file an anticipatory bail in connection with Bhangagarh PS case number so-and-so. Accordingly, complainant filed anticipatory bail under section 438 CRPC before the so-and-so, and the bail was granted. Then the story starts at paragraph 6 onwards. After obtaining the certified copy of the order of the granting bail, the complainant gave a copy of the said order to his client, namely he came down. However, since the client of the complainant was from the state of Arunachal Pradesh and not well versed with the Assamese language, therefore he requested your complainant to accompany him to the police station as he is required to give his statement under section 161 CRPC. The complainant, as a part of his profession duty, had accompanied his client to Bhangagar PS on 10/3/23, where the statements of the complainant client were recorded. Thereafter, the investigation officer of the said case asked the client of the complainant to visit the office of the Deputy Commissioner of Police East DCP, Guwahati at Dispur. As such, the complainant along with his client had visited the office of the DCP on 10/3/23. After waiting for about 3 hours, the DCP came to his office, and after some initial discussions, the DCP advised the clients of the complainant to again visit on 11/3/23. Accordingly, the complainant and his client visited the office of the DCP on 11/3/23 at around 11:30 a.m. While they reached the office of the DCP, Sri Ram Avtar Agarwal, the petitioner hearing lordship, who happens to be father of Sri Amit Agarwal, turned up along with one Sri Girin Tekka, an unknown person claimed to be his chartered accountant, as the complainant and his clients were discussing the matter in presence of DCP Dispur in his official chamber, and the complainant learned that Sri Ram Avtar Agarwal was trying to settle the disputes between the client of the complainant and his son forcibly in front of police officer. The complainant, being appointed counsel of his client and as being discharging his professional duty, straight away rejected the forceful offer of settlement by Sri Ram Avtar Agarwal, stating that Sri Amit Agarwal has already instituted a civil suit against the client of the complainant, which has been registered as miscase arbitration case number 16 of 22 for recovery of some vehicles and machinery which are part of FIR number so-and-so of Bhangagar PS case, upon which, first of all, Lordship, the complainant himself was present in the place at the stage of compromise. He was not supposed to be present there. Now what has happened, Lordship, at the stage of compromisation, upon which Sri Ram Avtar Agarwal furiously started to abuse the complainant with an oral comments and remarks by touching the body of the complainant, stating loudly that the presence of the advocate always creates problem and the advocate present is not required. The intention of the advocate is never to settle the issues, rather advocate only intend to drag the dispute further for making money. This is a statement. Then a Lordship may turn to his statement recorded under section 200 CRPC at annexure 3, page 58. The relevant part I'll refer to as page 59. 6th line from top, Lordship. At that time, DCP sir came there and called both the parties in his chamber. Then DCP sir asked our name. I gave him my identity as the advocate of my client, on which he requested me to sit outside. On his requested, I left the chamber. I was given a cup of tea there by a constable, and after 10-15 minutes, DCP sir called me in his chamber. When I entered into the chamber of DCP sir, accused Ram Avtar Agarwal asked me to compromise the matter, but I immediately replied him that I could not do so as the matter is already under judicial purview. Moreover, the informant of the case, Sri Sanjeev Sharma and other important party, Amit Agarwal, were not present there. Hearing my reply, the accused Ram Avtar Agarwal told me in Hindi that वकील होना ही नहीं चाहिए, क्योंकि वकील कभी भी नहीं चाहता है कि केस कॉम्प्रोमाइज हो. पैसे के लिए वकील कुछ भी करेगा. I also replied him that बिना एडवोकेट आप एक केस सॉल्व करके दिखाइए. I also told him that वकील कभी छोटा या बड़ा नहीं होता है. Hearing my reply, the accused tried to shake hand with me, stating that आप तो मेरे लड़के जैसे हैं. But I simply told him that he had already defamed me. So here the statement was made to the accused, the complainant himself, and not to any other third person. There was no publication or making of the statement to any third person. Then after Lordship, the subsequent paragraph, at that time my client requested me to outside and have a discussion over the matter. My client also told me that they don't want to compromise the matter at all. After having discussion with my client, I again entered into the chamber of DCP sir and told him that I am not going to compromise the matter as the accused misbehaved with me in front of him as well as the IO of the case. Moreover, the case is under judicial purview and hence the matter would be decided by the Honorable Court only. So the purpose of non-compromise, he has stated that because I have made so statements, so he is not proceeding with the compromise. Then after the witness he has produced, Lordship, his statement is recorded in Annexure 4, page 61, under 202. The relevant part of the statement is page 62. Lordship may come to 10th line from the top.
Mm.
Then my counsel
Mm.
told DCP sir, my client condition by for cleaning his name from the honorable judge or making agreement through notary is not being accepted, and moreover the main complainant Sri Amit Agarwal is not present, and let the matter be decided by the court. The DCP said that he wanted to compromise the matter as I have come from Arunachal, and since he does not feel safe, let the matter be decided by the honorable court. At that time, Ram Agarwal got very angry and uttered, एडवोकेट वैसे ही दलाली करता है और केस को कॉम्प्रोमाइज नहीं करता और लंबा खींचता है पैसे खाने का धंधा में. My client and Ram Agarwal started arguing. My counsel and Ram Agarwal started arguing there, and DCP intervened and told them to stop arguing there. Here, let the matter be decided at the court. So this is a statement which has been recorded by the witness. Now my humble submission to your lordship is that for essential ingredients of 499 of IPC is there. The statement or the publication has to be made to a third person. It is directly in a matter of conversation with the person complaining himself. So there is no publication as such. Secondly, even the witness has not stated that such statement has maligned the reputation of the complainant or in his esteem, or that his reputation is reduced in his eyes, and that is a statement. Now, Lordship Mehta, the explanations of 4 of section 499. First of all, I'll read section 499, Lordship. Whoever by word either spoke.
IPC को
IPC.
Yes.
First of all, I'll read section 419 Lordship. Whoever by word either spoken or intended to be read, or by signs or by visible representation makes or publish any imputation concerning any person intended to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said, except in cases herein expected to defame that person. Explanation 4. No imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers the moral or intellectual character of that person or lowers the character of that person in respect of his caste or of his calling or lowers the credit of that person or causes it to be believed that the body of that person is in loathsome state or is in a state generally considered as disgraceful. Now, Lordship, first of all, the statement was a part of conversation between the complainant and the accused themselves. It was a general statement in nature and no specific allegation against the complainant. First of all, the statement, and second, Lordship, the statement was made to the complainant himself and not published to any third person. And no witness states that the reputation of the complainant has lowered by that statement or he has been defamed in the eyes of that third person. So there can be no offense of defamation unless the defamatory statement is published or made to a third person and or party person other than the person who is alleged to be defamed. So in my humble submission, Lordship, this case is not maintainable and no prima facie is a case of 499 IPC. And in this reference, Lordship,
No. It's okay. I think he has the police station is a public office,
public office,
and then the witness was also present.
witness of
I do not agree. I do not agree.
but it was a part of the conversation, Lordship, where
You see,
it
this
is
is,
not that complainant
this
is
is
of
already
such
there.
character.
This is already there. Now at least now I do not agree. Maybe later. See, this is already there. Lowers the moral or intellectual character of that person or lowers the character or of his calling. Of his calling, he is an advocate.
Yes.
So I do not
But
agree.
that is a general statement, Your Honor. But prima facie, it has to be that
It's
it
not
has
a-
lowered the.
and it's in the office and there were many others present. At least at this stage, I do not agree to grant stay.
at least notice may be issued.
Yes,
This stage.
notice will be issued.
If your lordship may, I'll just take a lordship for timing one judgment by this honorable court, where it has been stated that even
But the
the,
code, according to the code, I do not find any wrong in taking cognizance.
but he feels himself
no
to be
error
framed, but a
apparent.
statement only when it has made to a third person, it will be a defamation. When I made the person the complaining himself, at
At
max
this
it
stage,
is a
not at
case of
this stage.
insult and not a defamation.
Not at this stage. I've heard you at length. No, I'm not actually not at this stage. Maybe later.
Lordship.
Then we'll go through the judgment and everything.
Lordship.
Third learner counsel, Mr.
Dr. A. Todi.
Dr. A. Todi for the applicant, who has filed for the applicant Ram Akhtar Agarwal, who has filed this application under section 528 of the BNWS 2023. We pray for quashing the complaint case being CR case number so and so under section so and so. And Mr. PS Local Learner Edition PP for the respondent number 1. It is submitted on behalf of the applicant that the conversation between two individuals cannot be misconstrued to be an offense under section 500, 499 stroke 500 of the IPC. And this is a fit case to be quashed and set aside as further proceeding will be an abuse of the process of the court. Issue notice to the respondent number 2, returnable within 4 weeks as per usual process. As per usual process, returnable within 4 weeks. Meanwhile, call for the scan copies of the trial court record. The prayer for interim stay may be considered after receipt of scan copies of the trial court records. List accordingly.
Much of pleasure.
May it please your lordship, my lord, this is a quashing application
Oh.
against a complaint case, not a, is a complaint case. My lord, the petitioner number 1 is the husband,
Oh.
2 is the mother-in-law, 3 and 4 are the brothers-in-law, and 5 is the sister-in-law.
Oh.
The complaint case prayer is at page 21.
Video finding is page 21.
21 is the prayer in the complaint petition. Here the government is a formal party.
Okay.
My lord, the prayer in page 21, therefore it is raised before your honor to admit the petition register the same under the above section, issue search warrant against the accused person, recover the below articles. These are the Sridhan property. Sridhan concept is only with the Hindu law. Mohammedan law is not governed because at para I have stated, my lord, I have already given her talak and she is entitled to meher or dawar, whatever it is. Concept of Sridhan is only section 26 of the Hindu Marriage Act and 16 or 14 of Succession Act. So this is that Pothivarani's case of 1985 also deals with Sridhan articles and says those are related to Hindu law. So we are governed by modern law. She is entitled to meher or dawar on the contract of marriage. So here now the court has issued my lord, what I say, notice on the respondents. And moreover, my lord, the petition number 4 is an advocate from the Guwahati High Court. My lord, and these are brother-in-law, my lord. So, my lord, here the basic fundamental of Bhajanlal case, which has been reiterated again, which is bar at law, cannot be proceeded, my lord. So I pray, my lord, at this moment, my lord, there may be a stay of the proceeding of the complaint case. Because, my lord, here Mohammedan law does not go with the Sridhan properties. Absolutely. And it is an admitted fact, my lord. And these are all related to Hindu law. Sridhan 406 and others, that in that case of Pothivarani, it has said, my lord, that section 27 of the Hindu Marriage Act and 14 of, my lord, Succession Act. So that will go with that Hindu law, Sridhan property. Here they are entitled to only mahar and dawa. So their Sridhan property concept is not there in the Mohammedan. And the trial court, and moreover now what has happened, my lord, after the court issued notice, she doesn't take steps. For 1 year, the orders will pass, your lordship will find. She is also has lost the hope, I think, my lord, from page onwards, page 28. 7-10-24. Page 28,
But what about the articles? You're not willing to give it back.
my lord, articles,
Those are very valuable articles.
but these valuable articles, whether it belongs to her or not, has to be proved. That cannot be, because the concept of Sridhan is not there. Ma'am. She has written Sridhan. In her prayer also, she has written Sridhan. Where from this will come, my lord? At page 21 itself.
Let me see the judgment.
This is the judgment of Pratibha Rani. This is all related to Hindu law. Page 21, second line. There is possibility of damage of my Sridhan articles.
Okay. Which paragraph of the judgment?
My lord, I think I have only one copy. Your lordship will find that it has dealt with section 26 of the Hindu Marriage Act and 14 of the Hindu Succession Act. So it has dealt with 406 and in relevance to that Hindu law.
Pratibha Rani is a Hindu woman.
My lord, Hindu, that is why.
Yeah.
That is why what I want to say that this Sridhan articles, if she is claiming, she is governed by Mohammedan law. She is governed
This will not come here, Mohammedan law.
because my
This
lord,
is under section 406 IPC.
40 now presently it is this. Now
She may refer to his student articles, it's okay, but it is
Because-
under 406 IPC.
406 criminal breach of trust, and my lord, here my lord, what my submission before your lordship is this. At this moment, at least your lordship may regarding the petitioner number, because
Gold necklace, gold earrings, gold bracelet, gold ring, golden chain, gold nose ring, silver anklets.
but since my lord, your lordship will
wooden
find,
plank, Godrej, Almira, sofa set, you don't want to give those back
but from since
to
2020,
the
page 28
victim.
onwards, page 28 onwards, she is not willing to take any steps in that work. Your lordship will find from 7-10-2024, page 28, complainant is to take steps. Next, my lord, 24-10-24, complainant is to take
Family law है, कौन को रिवर
maintenance only directed for shelter lordship. So at this stage, I pray lordship let a notice may go lordship because there is an infirmity because section 12(1) was not complied with by the learned court below.
Our learned counsel, Mr.
K. Mujumdar lordship.
A. Mujumdar for the petitioner X who has filed his application. Under 528 of the BNWS 2023, as the petitioner is aggrieved by the judgment and order dated 7/3/2025 in CA number 91 of 2023. And also the order dated 30/11/2023 in connection with DB case number 2 of 2019. Call for the scanned copies of the aforementioned cases, issue notice to the respondent.
A short date may so that she can get some relief lordship.
Issue notice to the respondent,
Because
returnable
I am not praying for any
after 2
stay.
weeks. Returnable after, as per issue process, returnable on 19 June. List accordingly.
Lordship. I'll take steps within 2 days lordship.
March of life.
You'll have to take steps within 2 days.
But
I'm giving you a short date,
Lordship,
19 June,
yes.
yes.
I'll take steps
Yeah.
by tomorrow.
Item number 45.
But by way of this petition, my lord, I'm praying for transfer of a proceeding that is pending before the CBI court Assam to Arunachal, my lord. If your lordship may allow me to directly take your lordship to the,
We have no objections. Let the appropriate order may be passed here for transfer.
Okay, okay.
CBI has no objection.
Jurisdiction falls in Arunachal Pradesh.
I don't have.
Yes,
jurisdiction.
because the entire cause of action has arisen in Arunachal, my lord, and that's apparent from the charge sheet, my lord.
Why this case was registered here then?
I don't know, my lord, because maybe the CBI Assam investigated and therefore they assumed that it would be the jurisdiction. And the district and session judge UPI is designated to take up cases under PC Act.
UPI court.
UPR.
Yeah.
UPR. Under
Page
section
53 of my
4,
petition, my lord,
is
will can.
The BNWS, no, I am also not, I'll have to go to the section because you see,
My lord,
I'm also not familiar with BNWS.
my lord.
I'm just learning 447 of the BNWS. I'm still at the learning
My
stage,
lord, everybody was my lord. It's a bit confusing.
very much confusing. And some new procedures have also been introduced.
Yes, yes. Billing line again, एक तो एक day billing. DNFS. Yes. This is protocol like that. About to listen to select state will
Transfer. That is from one state to another.
So 447, it's okay.
Yes.
Which 447, which
447, I think, my lord, B and C both will be applicable, my lord. Because under 173 million, 178 million,
Hmm.
it is the Arunachal court which has jurisdiction to try as the offense was committed within the local jurisdiction. And C also, my lord, for convenience of because all the witnesses are from Arunachal. The accused witnesses, everyone is from Arunachal.
and vis-a-vis the rules
Well-
of this high court, which will fall under which rules?
Like rules that I have not checked up. 447, otherwise lordship can because it is within the jurisdiction of this honorable court, my lord, this CBI.
State to another state. The honorable court has jurisdiction.
Hmm?
From one state to another state, any transfer can be passed
Under
by
the
the.
CRPC, it was okay, but now under the Samhita,
Wow.
I think it's not clear here. Under CRBC, it was very clear.
Yes,
Yes.
CRPC, it was very clear.
Very
but
clear.
in
Here it is not.
It was
BNN
447 also, my lord, if your lordship kindly see.
They couldn't find.
Here, it visualizes three conditions, my lord, 447. One is that a fair and impartial inquiry or a trial cannot be held in any criminal court subordinate thereto. That some question of law of unusual difficulty is likely to arise. That an order under this section is required by any provision of this Sanhita or will tend to general convenience of the parties or witness or is expedient for the ends of justice. Now, here, my lord, here two aspects will come, my lord. One, the
Cause of action arose in.
yes, cause of action arose
there.
arose in Arunachal, and therefore the word ordinarily in 178, my lord. That would be the court in Arunachal, my lord.
Yes, yes.
And the second, my lord, third was also of convenience, where the my lord, all the witnesses accused, everyone is from there. In fact, it would facilitate the prosecution to conduct the trial, my lord.
Cause of action arose there in the Arunachal.
Arunachal.
That is there. But the investigating agency is the CBI Guwahati based on Guwahati. There is a
CBI
notification.
is Delhi based.
Yes.
They have office at Guwahati.
Guwahati also, yes.
Other rest, all the prosecution witnesses are from Arunachal.
There is a one proviso.
No, it was rejected.
Was rejected.
There is a proviso that
Proviso clause into 447 2.
447 2.
Proviso
That
clause. It was
first-
rejected.
First, the parties has to approach the court, the trial court.
That is for sessions.
Yes.
Sessions case.
But yet, here also we approach it. Page 49 is the order, and the Direct Court below has expressed his inability to transfer as it relates to a different state.
Where is the?
Page 49 is the order, my lord, passed by the special judge CBI, my lord.
We have this in law clear. We have to
Mm.
make the-
Page 51 is the observation of the court. My lord finds page 51, third paragraph. As it being an interstate transfer of this case, of which this court has no jurisdiction at all, and as such, without going into the merit of the submission for transfer, I am of the considered opinion that this court has no jurisdiction to consider any prayer for interstate transfer of a criminal case. In view of the above, the petitioner of transfer stands rejected with a liberty to the petitioner to move the competent jurisdiction to raise their grievances. Now, this High Court will have jurisdiction because as it is the principle,
Yes.
the High Court is.
Yes, yes. I agree with you. I'll pass an order.
Well-
Hard learned counsel, Mr.
The Quashing, madam.
B. Koshik for the petitioner. KK Young, petitioners KK Yangpo and others, and another. And Miss M. Kumarina,
Yes.
for the respondent, learned
Standing council CBI.
standing counsel CBI. This petition has been filed under section 447 of the BNWS 2023 with prayer for transfer of special case number 3 of 2024 arising out of CBI ACB Guwahati case number edul sabare liba capital likhiba sab RC 01 72018 capital A 0014 within bracket RC 14 within bracket ACO A bracket close stroke 2018 hyphen GWH comma bracket close comma pending before the learned special judge CBI Guwahati and registered under so sections. It is submitted on behalf of the petitioner that although the CBI was the investigating agency, the cause of action arose at Arunachal Pradesh. Where is the FIR?
Plus, it relates to a contract by the army, my lord, and for supply of vegetables to the army battalion in many different districts of Assam, Arunachal.
Arunachal Pradesh. FIR?
FIR, my lord, your lordship will find, starts from page 21.
Full stop. The FIR succinctly reveals that the petitioners no, have
Hello.
failed to supply vegetables to different districts of Arunachal Pradesh. As the terms and agreements of contract between the petitioners and the whom? Army.
My army.
And the between the petitioners and the army.
556 Army Supply Corporation Battalion.
556 Army Supply
Battalion Likhabali, Arunachal.
Battalion Likhabali, Arunachal Pradesh. The petitioners had earlier approached the learned special judge for transfer of the entire case to Arunachal Pradesh, who further submitted that all the witnesses and the accused are also from Arunachal Pradesh. Who stopped the learned special judge, CBI, no?
CBI.
CBI, who did not have the jurisdiction, who does not have the jurisdiction, has rejected the petitioner's prayer for transfer of this case to Arunachal Pradesh, it is also submitted at the bar that the session judge.
District and Session Judge, UPA, as a special judge.
The session judge, district and session judge.
District and Session Judge,
UPA is the special judge to deal with the CBI cases.
CBI cases.
This is
offenses under PC Act.
Huh?
Offenses under PC Act. And
District and session judge, CBI, is the
Try the offences under case.
is
designated as,
designated
page
as
53 is the notification.
is designated as special judge to as what?
Special judge to try all offenses under PC Act
Special judge to
investigated by
try
the
all offenses under the PCI.
under PC Act investigated by CBI.
A PC Act investigated by the CBI. The proper the court with the proper jurisdiction will be the district and the court of the special judge, i.e. session judge, UPI. All right. Then the remaining part, I will pass the order. I'll go through the rules and everything.
Yes.
And
Grateful.
accurately, I'll pass the order.
Grateful.
Today itself, I'll pass.
The next date fixed is 10th, my lord.
Before that, I'll today itself, I'll pass the order.
Yes. Very good. Grateful, one.
But for appearance, that is the date next week.
Lordship perhaps will have to fix a date for appearance
Date
there also.
Appearance in the
Okay,
UPI.
he doesn't
That
like
date has required to be fixed.
when the case will be transferred, no, to appear before the date to be fixed for
It
appearance
will take
before
15 or
UPI.
20 days. 15 or 20 days, some date. kindly.
Anyways, any convenient to
Fix
you.
a date, longer date maybe, 1 month's date. Maybe.
Grateful, one.
Much. It was salable, salable.
Items, currently or
Has no objection, it was some learned senior counsel, learned standing counsel here. CBI has no.
Absolutely, Your Worship. This is an appeal against conviction, my lord. Again, judgment and order acted 2/5/25, my lord, passed by the learned special judge Nalwari, my lord, under section 20B and C, my lord. Appeal may be admitted, my lord, at this test, my lord, and LCR may be-
Learned counsel, Mr. D. Bora is present. For the appellant, one appellant. For the
One, my lord.
appellant, Elias Boga, learned additional PP. Mr. B. Sharma is present for the respondent state. And has accepted notice on behalf of the respondent. Thus, no formal notice is required to be served on issued litigation. So notice is not required to be issued. You have accepted notice. Admit, call for the trial court records.
my lord.
But here respondent number 2 is here, last sheet, by name.
Okay.
Sorry,
Issue
sir,
notice to respondent number 2. Returnable after returnable on after 4 weeks.
my lord.
Uh,
There is an IA, my lord, that may be taken after the receipt of LCR.
uh,
I is for bail, my lord.
Okay. Learned counsel, Mr. D. Bora is present for the IA to Ligma applicant. Learned additional PP, Mr. B. Sharma is present for the respondent. Respondent state, call for the LCR. Meanwhile, also here also you have arrayed respondent number 2.
Yes, my lord.
Issue notice to respondent number 3. To register post. On as per usual process, returnable within 4 weeks, call for the LCR. This IA will be taken up after receipt of LCR.
My lord.
Lord, this is a compromise, lordship application under section 528, seeking quashing of a proceeding where both parties have duly compromised the matter. So this case
Number 2 and 3.
case charge has been framed under section 498A, 377 and 506. Now, lordship, this case arises out of a matrimonial dispute between the parties. Now, all the the matter has been amicably settled between the parties. I have also annexed a copy of the MOU, which shows that the second party has also agreed. And she will have no objection if any quashing petition is filed. She will give no objection to the case. That there is a clause also in the MOU which lordship will have at page 30.
Page 30.
Yes. Page 30, annexure. Annexure 4. Clause number 5 of the MOU, that it is mutually agreed between the parties that during pendency of the aforesaid divorce application and after payment of the aforesaid 90% of the total permanent alimony, the parties to the instant proceeding shall file one application before the Honorable Guwahati High Court for quashing of GR case number 548/2016.
So these parties have been divorced.
Divorce petition is pending, my lord.
That is pending.
Actually, we have received the 90% of the alimony, and the condition was that mentioned in paragraph 5 of the MOU, that after payment of that amount, the husband filed a quashing petition before this honorable court. After quashing of this, we can file a divorce petition, finalize the divorce petition, final decree. And we will receive the remaining 10% of the alimony. We have received 90%, right? And we have no any objection if this honorable court allowed it.
This is a joint petition or a
No,
separate
not
petition?
joint petition. Notice was issued.
Okay.
LC, scan copy of LCR records have also come.
Third learned counsel, Mr. A. Ganguly, for the petitioner, naam to likhe hona lage, who has filed his application under section 528 of the BNWS 2023 with prayer for quashing the proceeding in GR case number 548 of 2016 under section 498A stroke 377 stroke 506 of the Indian Penal Code within bracket IPC for short bracket closed. pending in the court of the learned JMFC Bozali Patsala. Heard Mr. B. Sharma, learned additional PP Assam, and learned counsel Mr.
PP Botakur.
PP Botaku for the respondent number 2 and 3. The respondent number 3 is the wife of the petitioner,
Yes.
and the respondent number 2 is the victim's mother.
Mother of the
Victim.
respondent number 3.
Is the victim's mother. Full stop. I have considered the submissions at the bar with circumspection. It is submitted that both the parties have amicably settled their dispute and an MOU.
Yes.
Deed of memorandum of understanding was executed. Deed of memorandum of understanding was executed between the between both the parties. Full stop. Annexure 4 is the deed of MOU, which clearly reveals that both the parties have amicably settled their disputes and buried their hatchet. A divorce proceeding will unalienable. I have scrutinized the entire deed of MOU. It appears that the possibility of conviction appears to be remote and bleak, as the complainant, as the victim has executed the deed of MOU, and there may be no evidence against the petitioner. Full stop. It appears that further proceeding will indeed be an abuse of the process of the court. You have any supporting authority?
Yes.
Judgment?
Narendra Singh, 2014, 6 SSC 46.
The petitioner has also relied on the decision of the Honorable Supreme Court in Narendra Singh versus the paragraph
Paragraph 29.
in Narendra Singh and others versus the state of Punjab and another reported in 2014 6 SCC, wherein it has been held that paragraph 29, huh?
29.4 mentions of matrimonial relationship.
Paragraph 29.4 likhi ba.
On the other hand, those criminal cases having overwhelmingly and predominantly civil character, particularly those arising out of commercial transaction or arising out of matrimonial relationship or family dispute, should be quashed when the parties have resolved their entire disputes among themselves.
Paragraph 29.4. I find force in the argument of the I find force in the light of the decision of the Honorable Supreme Court in Narendra Singh's case Supra, this petition is allowed, and the entire proceeding of GR case number so and so is quashed. In terms of the above observation, this petition stands disposed of.
Obliged.
For orders.
Made your this is one first step in Milord.
Hmm.
There is a delay of 546 days, Milord.
Hmm.
Here, my lord, the fact is this, Milord.
Delay 546 days.
Yes.
Hmm.
I have filed 2 IA, Milord. One is for condoning the delay, and another is, Milord, recently the executing court, Amingaon, Milord, they have received writ against this, Milord, petitioners and appellants, Milord. Therefore, this 1620 of 2025 IA is filed to, Milord, stay the order passed by the Learned Executive Court, Milord, which is at page, Lordship, kindly peruse.
Which one?
In
There are two IAs, no?
IA 1620.
1620 read.
Yes, Milord, IA.
No, but we'll have to first come to the condonation.
Delete
Yes,
3368, IA 336.
First we'll have to come
yes,
here.
that is, Milord, 3368.
Yes, you want to say something?
Yes, ma'am. I have filed my objection, my lord,
Hmm.
for the respondent number 1. Apart from the objection, I would like to also point out page number 2 of the IA, my lord, where party number 6 is suffix, my lord, who has been made as petition number 6 as well as respondent number 2, my lord. So this cannot be, my lord, that the petitioner and the respondent is one and the same person, my lord. So
Which
can-
one? IA?
IA, my lord.
Which
Page
one?
number 2, my lord. IA
336.
33, yes, ma'am. 336. Page
What-
number
what?
2, petitioner number 6.
Petition number 6, Sofik Bosabi.
And page number 3,
Respondent number 2.
2, same person.
Same person.
Yes,
This
ma'am.
person, my lord, he was the manager of this firm, proprietorship firm.
Whatever it may be, my lord, the same.
No.
person.
What happened, my lord?
No, no.
No, my lord.
No.
What happened?
No,
This is
In
not
collusion
contained.
with,
no.
in collusion with this respondent, my lord. He
You
has
just,
received the,
you remove him from any one arraignment. Either from petitioner's arraignment or from respondent's arraignment. You remove him. You'll have to remove him.
he is a respondent, my lord, necessary party. If
Then let him be a respondent, not a petitioner.
Yes, my lord.
They have to withdraw and file a fresh petition.
Amended petition.
My lord, in the meantime, what happened? The writ has been issued.
Read may be issued.
I have been waiting. my
First,
lord.
IA has to be disposed of relating to condonation of delay.
In condonation petition, my lord, if your lordship kindly.
No. You'll have to remove him from arraignment from either as a respondent or as a, and that too you'll have to file an amended petition.
There are total 6 petitioners are there.
No.
Lordship may kindly see.
No.
In the condonation
No,
petition.
you have to remove him from at least from top or from the bottom. You'll have to remove him. You'll have to remove him.
As a petitioner, my lord.
It's up to you. You want to place him as a petitioner or as a respondent, it's up to you.
No, he is a respondent in this condonation petition. My lord, what happened?
Make him
No,
a
it's a-
respondent. File one, now a writ may be issued, everything may be attached. I cannot help you now. First delay has to be condoned and then either you make him a
No, what happened,
respondent or
my
a
lord?
petitioner.
The format, it appears that the party who were, my lord,
No point.
defendants, my lord, are appellants. First of all, this, my lord, condition to be fulfilled for filing. That's why he is a party, my lord. But secondly, the respondent,
Okay, I'm saying he's a party. He
then
is a
his
party.
lordship may, my lord, his name may be deleted from the petitioner.
For that purpose, amendment.
No, my lord, here your lordship may pass an order as per my prayer.
This cannot be, my lord.
There cannot be.
He can be petitioner or he can be respondent. He
No,
cannot
you
be
see,
both.
No, if at this
I
stage,
can pass a prayer. I can pass an order.
to delete the name of the
yes.
petitioner number 6.
I can struck off anybody's name.
Yes,
But when
yes.
this error has come like this, I don't think I can pass any order. You'll have to file an amended petition.
No, my lord,
Because you see, I do not want to decide.
this is a format, my lord, because otherwise this registry will not accept. All the petitioners are not before this honorable
Why
court.
then? Why did the registry accept?
It's the
this?
thing.
This is a.
He is a
format, but
necessary,
they have-
এক minute.
Why
It-
has the registry accepted this then?
Because he was my manager in the
Sofik
farm.
versus Sofik. Why did he registry accept Sofik versus?
No, my
Sofik?
lord, at this stage, your lordship may delete the name of this
I will not
petitioner
decide.
number 6.
I will not decide. Why should I take the burden upon me? Whether he is a respondent or whether he is a petitioner, you will have to satisfy. Sofik versus Sofik that at that time registry has
My
accepted,
lord, what happened? Yes.
and now the registry won't accept. When you make N versus Sofik, then the registry won't accept, and then the registry accepted when you made it Sofik versus Sofik.
My lord, he was earlier our manager. What happened? He was defendant. Like this petitioners.
No, see, it's okay. It's okay. It's okay, but
This is
it
ex parte order.
it has to be given in a proper manner. Whom you want to, it is up to you. Why should the court take the burden to decide or
Yes,
orally?
my lord, I am the appellant. I can pray before your lordship.
Pray, yes,
And
you
your
can
lordship
pray.
has the power.
Why not in black and white? Why not in black and white?
This will cause delay, my lord, and this writ has already been issued.
For this court
And this
already,
registry, my lord, they have received notice long back, about 3 months back.
that is what I am saying. This registry, when they accepted it, Sofik versus Sofik, now they won't accept N versus Sofik or X versus Sofik or Sofik versus X. It's okay, oral submission, I can strike off any parties. If the party is only single party, I can strike off, it's okay, but now why should I take the burden to decide whether he's a respondent or whether he's a petitioner?
As because he was made one defendant there, and this is ex party, then therefore he was made a party petitioner
That is what
also.
I'm saying.
But
If it comes in black and white, it is good for the court. Why should the court take the burden? Isn't
then
it?
your lordship may pass it.
Yes. I'll fix a
To
date.
strike out the name of the petitioner number 6.
I'll fix a date. You pass an amended petition to file an amended petition. That will be better, I think.
Yes.
But I cannot ask her also now. What will be better? I cannot ask her also because she will say this will be better. Because she is always ready
No,
to
because
keep
my
the
lord-
burden on you.
Because
So
there is
she will say
urgency,
this is
my
the
lord.
better way, huh?
There is urgency because it has
Understand, because it has been issued, but it has not been attached. Has it been attached? It's a
not yet
property.
asserted, but my lord, they have taken steps.
But my lord, there is delay of 546 days. Definitely, I am going to place.
Delay, there are,
objection
my
to
lord,
my lord.
hundreds of my lord, decisions of the Honorable Supreme Court. More than 1,000 days, Honorable Supreme Court has allowed because there must be merit in the suit, my lord.
Correct, correct. I have also allowed that day.
Yes, yes.
1,300 and how many days? I have
Yes,
also
it's
allowed.
only 546 days because after passing of the my lord ex parte decree, they have when we have received the my lord execution case notice, then only we came to know. Then we have obtained the certified copy of the plain as well as the documents.
Sufficient cause in that case, my lord, then the condonation delay will be accepted, my lord. Now, if the petition does not have sufficient cause, my lord, then I will argue, my lord, at the time of hearing, my lord. So at this stage, amendment petition will be filed.
Short date? Day after tomorrow?
No, my lord. Because they are from Nalbari and at this stage, my lordship knows they are celebrating their. So
Right.
next week.
Next week, okay. Learned Counsel, Mr. R. Bhutnagar is present for the litigant and has submitted to auto 3368 or Dikiba, submitted for time to file an amended application. List the matter on 6.
Much obliged.
Obliged.
তো অলপ অফ কৰি দিবা জাজমেন্টৰ ডিটেকশন
Day before yes.
শুনিব নালাগে
First page is not required, Lordship. That there is page number 8 of internal page, Lordship. Page number 8, that is not required. So page number 9, Lordship. I am reading from page number 9, Lordship. I have not produced and exhibited any documentary evidence to show that the central government has empowered by general or special order in writing to me to enter, search, seizure and arrest without warrant. But as per NDPS Act, we are authorized to do so. At around 8:10 in the morning, we left for Birdaimalu Road, Guwahati from our office. I have not intercepted any oil tanker from 8:10 to 9 a.m. on 28/1/2017. I have not issued any order in writing to the aforesaid 2 persons to be witnesses during search. I have not issued any order in writing to the aforesaid 2 persons to be witnesses during search. That aforesaid 2 persons, that independent.
they have not been examined.
Yes, they are not examined. So I have not recorded any findings to the effect that the said 2 persons were independent and respectable inhabitants of the locality. It is not a fact that 2 independent witnesses, namely Muhammad Dilabor and Israful Haq, are not independent witnesses of this case, but our own interested witnesses. In Exhibit 3, there was no acknowledgement of the accused to show his receipt or service of Exhibit 3 upon him. On the spot, on 28/1/2017, I did not inquire what is the education qualification of the accused and which medium he studied, which is required, Lord. So it is not a fact that since I did not serve Exhibit 3 upon the accused, he did not reply to Exhibit 3. I disagree that no reasonable man would believe that a driver can understand the contents and language of Exhibit 4, which is the notice under Section 50 law. It is not a fact that Exhibit 3 and 4 were prepared to make out a false case against him, and I never served any notice
under section 50 of the NDPS Act to the accused. In my evidence, I have deposited that introduction was given to the accused by showing our identity card. Going through the case record, I cannot say that I have introduced ourselves by showing our identity card to the accused. The accused did not try or attempt to flee away at any point in time. It is not a fact that I have not followed the provisions of section 100 CRPC while making search. Lids of the oil tanker was locked and sealed. I am not aware about the rules and procedures followed while loading, unloading, and transporting the petroleum products by oil tanker. I am not aware that beneath the lid of the oil tanker, there was a valve attached to flow the petroleum products inside the oil tanker. I cannot say from my evidence given and from Panchanama Exhibit 7 as to who and how the lids of the oil tanker were opened. I did not mention how many lids were there in the oil tanker. I did not mention in any evidence and Panchanama what was the size of the valve. I did not mention in my evidence and Panchanama whether the oil tanker was full or empty. I have not mentioned in my evidence and Panchanama whether any photography and videography were made during search and seizure. I have not recorded the weight of the oil tanker before or after search. It is not a fact that there was no contraband inside the oil tanker and I did not recover any packets of contraband from the oil tanker. It is not a fact that for extraneous consideration, we made out a false case of recovery of 139 packets of ganja to frame the accused. In my evidence and Panchanama, Exhibit 7, Test Memo, Exhibit 6, Search and Seizure List, Exhibit 5, I did not mention the size of the packet, that is the length, breadth, and thickness. The material exhibit number 52 produced before the court today. On measurement of the exhibit 52 produced before the court, I find that length is 21 inch, breadth is 12 inch, and thickness is 5 inch respectively. The drug detection kit and its test result on particulars on 28/1/2017 was not produced before the court. So, Lordship, on the initial, they throw that drug detection kit they identified, but that was not produced. I sealed
It's not required. We have the forensic report, no?
Yes, Lord. I sealed the seized articles on the spot on 28/1/2017. I did not know what is the nearest police station where I conducted search and seizure upon the accused. I did not forward the seized articles to the officer in charge of the nearest police station. On 28/1/2017, before sealing the seized articles, I did not prepare the inventory in presence of magistrate and certified its correctness by a magistrate. So this is complete violation, Lordship. On 28/1/2017, before sealing the seized articles, I did not take photographs before the magistrate and certified the said photographs to be true by a magistrate. On 28/1/2000.
Violation of section 52A.
Section 52A, Lordship. So, Lordship, and moreover, Lordship, this is a primary evidence, Lordship, as per section.
Yes, yes.
So, in absence of primary evidence, Lordship, no case. I have already provided the judgments, Lordship. Your Lordship may kindly peruse all. On 28/1/2017, before sealing the packets of ganja, I did not draw representative samples in presence of a magistrate, which is mandatory, Lordship, and certified by him the correctness of the list of samples. It is a fact that officer in charge of police station and magistrate was not at all present on the spot on 28/1/17. I could not say from the case record that gazette notification of central government by which power of officer in charge of a police station has been invested upon me for investigation of. So, as per section, Lordship, 53, Lordship, as per section 52, Lordship, 52(3), every person arrested and article seized under subsection so and so shall be forwarded without unnecessary delay to the officer in charge of the nearest police station or the officer empowered under section 53. So he had not forwarded to the nearest police station, or he has he is not able to show that he is authorized under
No.
section 52.
He has forwarded. It is there in the evidence.
No.
In all, everybody's evidence, it is there.
No, he is not forwarded to the nearest police station, Lordship. That because in his cross he admitted this, Lordship, and in his chief also, Lordship, he had never said that we have forwarded him to the nearest police station or anyone, Lordship. That was no, your Lordship may kindly, if again peruse, Lordship, the chief Lordship, nowhere he stated that we have forwarded him to the, because he had, the seizing officer along with his team, Lordship, he had taken him to the NCB office, not to the nearest police station. So that was also weakened the prosecution case.
Just a moment. They have been taken to the NCB office, not to the nearest. police
Not
station.
to the nearest police station.
Okay. Please continue.
Yes, Lordship. So, moreover, Lordship, may I read just Lordship 52A subsection 4 of the NDPS Act.
I know, I understand.
Yes, Lord. That primary evidence, Lord. So that is here nowhere, Lordship. This primary evidence is absent. Yeah. So I did not produce any material evidence to show that a small quantity from each packet was taken out and mixed homogeneously to make sample in duplicate other than sample packets. It is not a fact that I made a false test memo, so as dispatch has been shown as on 31/2017 at Royal on 28/1/2017 itself. I have not exhibited original sample marked as so along with my evidence. The original were sent to FSL for chemical examination and remnant samples are available in the court. Before giving evidence, I have not called for the original sample marked as S1 so from the FSL. There is no acknowledgement of receipt by the accused Exhibit 5 showing the service of Exhibit 5 upon the accused. In my evidence, I have stated that all the seized articles package samples are produced before the court today. I did not produce the registration certificate so. Before giving my evidence, I did not take any steps to produce the tanker truck registration certificate of the tanker national permit license on ignition key before the court. I cannot read and understand Assamese dialect. In Exhibit 7 Panchnama, there was no signature of the accused. There was no acknowledgement of receipt by the accused in Exhibit 8. It is not a fact that I never served Exhibit 8 notice upon the accused. On 28/1/2017, the accused was in our custody. At what time the recording of statement made in Exhibit 9 was not mentioned. There is voluntary statement. At the time of recording the said statement in Exhibit 9, no magistrate was present. It is not a fact that statement of in Exhibit 9 is not admissible.
We have only, it is not required.
Yes.
Because this is not an evidence now.
Yes, Lord. Yes.
No point.
So the next Lordship, next page, Lordship. Being an officer, when a document is served, we mentioned the word received from that person. It is not a fact that Exhibit 10, 11, 12, and 13 are false and manufactured. So this is last, Lordship. I filed the application before the CJM Kamrup Guwahati for pre-trial disposal of M Exhibit 1 to 113. As per I know, no order is yet passed. To pursue the petition, it is the job of the investigating officer. That, Lordship, that pre-trial disposal, that 52A, 52A, Lordship. I will show your Lordship 52A, which was exhibited, Lordship. Then, Lordship, I have not brought any written permission from my superior authority to dispose before the court today. To depose before the court today. It is not a fact that M Exhibit 1 to 139 was not brought from proper custody. In Exhibit 1 to 139 sealed on 28/1/2017, there is no seal and signature of any magistrate or officer in charge of the nearest police station at the time of sealing and seizure. So this is the cross of PW3, Lordship. Now, Lordship, regarding Lordship storage of that contraband, Lordship, because the chain of storage shall be lordship proof before the court that until it reached to the FSL. So now if your lordship first come to exhibit 10 lordship, which is the go down receipt number 1. Here lordship on 28/1 that contraventions were seized lordship. So on 28/1/2017, that all the above mentioned items are sealed with NCB brass seal so and so unit and entered into godown wide entry number 39/2017 of godown register. So that articles were lordship kept in the godown on 28/1/2017 at 8:10 hours. Time here written is 20:10 hours. Then 28/1 it was kept. Then on exhibit 11 lordship.
Exhibit 11 is?
Exhibit 11 that is goes down receipt number 2. That on 29/1/2017 all the above mentioned items are sealed with NCB brass seal number so and exited from godown for production in CGM code Kamrup wide entry number so of godown register. So that was exited for production before the Honorable CGM Lordship. Thereafter, that was
Okay.
thereafter Lordship Exhibit 12. Exhibit 12 that original samples for chemical examination that was sent on 31/2017. So on 29/1 Lordship that was exited from the godown and produced before the learned CGM. But from the court of learned CGM Lordship where it was kept till 31/2017 before sending it to the chemical FSL Lordship, that was not, no register was exhibited, nothing was exhibited. So the chain was not Lordship within that period where it was kept, that was not there. Thank you.
Okay.
Yes. So another important aspect, Lordship, Section 52A regarding compliance of Section 52A. So 52A2, that made it for a moment, Lordship, Section 52A2, where any narcotic drug, psychotropic substance, controlled substance or conveyance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under Section 53, the officer referred to in subsection 1 shall prepare an inventory of such substances, controlled substances, containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or other identifying particulars of the substances or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of such substances, consider relevant to facts that in any proceeding under this act and make an application to any magistrate for the purpose of. So last that 3A, B, C, that in the application Lordship, there has to be the prayer shall be made that A, certifying the correctness of the inventory so prepared, or B, taking in the presence of such magistrate photographs of substances or conveyances and certifying such photographs as true, or C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. So if your Lordship come to exhibit 14, which is the application made by that seizing officer, that PW3 Lordship, before the learned Chief Judicial Magistrate, the contents may I read Lordship. In paragraph 3 of that application Lordship, as required under Section 52A2, I submit the enclosed inventory of seized narcotic drugs, psychotropic substances, and request your honor to A, certify the correctness of the inventory. It is okay, Lordship. Then B, allow drawing of representative samples in presence of Your Honor and certifies the correctness of the list of samples sought. C, allow this application under subsection 3 of section 52 so the seized drugs can thereafter be disposed of as per section so and so, retaining the certificate and sample so and so, so and so. So here lordship, nowhere lordship, that prayer was made. And even then lordship, in his cross-examination, he admitted that whether that application was allowed or not.
To certify.
Yes, lordship, to certify. That he has not bothered to, lordship, allow, trade again lordship before
By
the
CJM.
honorable, yes, lordship, before the. So as per his statement, lordship, the entire representative samples were drawn in the spot. He had stated their
Yes,
lordship.
yes, on the spot.
On the spot, he had drawn the representative sample.
Yes.
And then it was kept in the, on 28/1, it was kept in the godown. And on 29/1, they have taken back for production before the CGM. Then where it goes till 30, on 31, they send it to the FSL and then lordship continues. But the Honorable Apex Court lordship in the various judgments lordship, it is categorically stated that representative sample shall be drawn in presence of the magistrate. And in absence of that, the primary evidence is absent. So in absence of primary evidence, lordship prosecution case is
Can be drawn on the spot, but the certificate is necessary.
certificate is necessary. So I am, lordship, not gone through all the evidence, lordship, because he is the prime evidence.
Two main factors and then which is missing.
Yes.
They have to answer now.
Yes, lordship. But your lordship, now I have given lordship some judgments, lordship.
Okay.
That Mohanlal's judgment, that is, in referring to the Mohanlal's judgment, lordship, that 2023 SCC online SC 498, I have given lordship that I have marked lordship 47.
23, Mohanlal judgment.
Mohanlal judgments lordship 2016. That
16,
was
yes.
lordship. I am not. That was their lordship because after referring these judgments, where there are subsequent various conclusive lordship. So I am referring it. I have given lordship the compilation of the judgments.
Okay.
They are page 47.
Page 47 of your appeal memo.
My compilation lordship.
Compilation is another record.
No lordship. Here lordship, I have given that judgments compilation.
Okay. Oh yes, it's page 47.
Yes, lord. Page 47, 2023 SCC online SC 498. That is lordship Botilal versus Intelligence Officers Narcotic Control Bureau. Here lordship, may I read lordship? Paragraph 14 lordship. Paragraph 14 to lordship 17. So paragraph 14, a finding was recorded by the High Court that prosecution has not proved that the witnesses are dead or cannot be found or rare, incapable of giving evidence or kept out of the way of the accused, or their presence cannot be obtained without an amount of delay or expense which under the circumstances of the case the court considers unreasonable. These findings are based on the perusal of the entire record. There is no explanation offered by the prosecution about their failure to examine these two independent material witnesses. Here are also lordship two independent material witnesses. They were not examined. And nothing regarding that whether they are dead or not. Hence, the statements of both the witnesses are not admissible in evidence. Next 15. Admittedly, PW2 drew two samples from each of the packets of the contraband found in the hotel room and kept them in two separate plastic covers. These covers were sealed and the remaining contraband was also sealed. Thus, the prosecution claims that the samples were prepared even before the packets were sent to the station house officer. The submission of the learned senior counsel appearing for the appellant in criminal so-and-so was that a grave suspicion is created about the prosecution's case as this action by the PW2 was contrary to section 52A of the NDPS Act. Next, paragraph 16, lordship. In paragraph 15 to 17 of Mohanlal's case, it was held thus paragraph, it is manifest from section 52A2 includes that upon seizure of the contraband, the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 53, who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for purposes of certifying the correctness of the inventory, certifying photographs of such drugs or substances taken before the magistrate as true, and to draw representative samples in the presence of magistrate and certifying the correctness of the list of samples so drawn. Next 16, subsection 3 of section 52A requires that the magistrate shall as soon as may be allow the application. This implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law duty bound to approach the magistrate for the purposes mentioned above, including grant of permission to draw representative samples in his presence, which samples will then be enlisted, and the correctness of the list of samples so drawn, certified by the magistrate. In other words, the process of drawing of samples has to be in the presence and under the supervision of the magistrate. And the entire exercise has to be certified by him to be correct. 17. The question of drawing of samples at the time of seizure, which more often than not takes place in the absence of the magistrate, does not in the above scheme of things arise. This is so especially when, according to section 52A4 of the Act, samples drawn and certified by the magistrate in compliance with subsection 2 and section 3 of the section 52A above constitute primary evidence. For the purpose of the trial, suffice it to say that there is no provision in the Act that mandates taking of samples at the time of seizure. That is perhaps why none of the states claim to be taking samples at the time of seizure. Next 17, thus, the act of PW2 of drawing samples from all the packets at the time of seizure is not in conformity with what is held by this court in the case of Mohanlas. This creates a serious doubt about the prosecution's case that the substance recovered was contraband. So everything, Lordship, Your Lordship, already on the as per statement of the seizing officer, Lordship, that all the judgments which I have produced, Lordship, that are also in the similar line, Lordship. Your Lordship may peruse it, Lordship.
Yes.
Then, Lordship, I reserve my counter, Lordship. They may.
Please, Your Honor. Today, my senior is not available because he is suffering from high fever. Your Lordship may grant us a week's time to file our written argument.
Written argument.
Yes.
Okay, 1 week's time, or see this person. I think he'll be out of the jail. So 1 week's time cannot be granted. Less than 1 week, because he's already after calculating his leave period and everything, I think he won't be remaining in the jail for long.
Yes.
So I cannot grant 1 week's time, but maybe 4-5 days time.
Next Tuesday, Lordship. That's part.
Next Tuesday, yes. Actually, our argument can to be note down. Korea more likely. Get a gap task any ki? Arguments will gap task na. Automatically, it not fill up with it. The learned counsel for the appellant, they stress in his argument that the cross-examination of PW3, the prime, the key witness, the key witness clearly reveals the perfunctory manner in which the search and seizure was made, and the petitioner and the appellant was taken into custody. It is submitted by the learned counsel for the appellant that the independent witnesses which have been referred to by all the witnesses have not been examined. the evidence of the witnesses reveal that there are two independent witnesses who were present at the time of search and seizure, but these independent witnesses were not produced by the prosecution at the time the evidence was recorded in the court. Full stop. The violation of Article 52A of the NDPS Act is evident. Full stop. The cross-examination of PW3 clearly reveals that the appellant, that search and seizure was made at the spot, but there is not a whisper in the evidence of the seizing witness, i.e. PW3, that after he made an application to the CGM for certification of the sample which were drawn at the spot, i.e. place of occurrence, were certified by the CGM as samples drawn, as samples of the contraband drawn. Full stop. The record reveals no certification by the CGM before whom the articles were produced. Seized articles were produced along with the samples drawn at the place of occurrence. In violation of Section 52 of the Act, the appellant was not produced before the police station within 24 hours, but he was taken to the NCB office instead of being taken to the police station along with the seized articles and the seized tanker. Full stop. The exhibit The Exhibit 10 is the go down receipt report, which reveals that the articles were kept in the in the go down of the seized articles area. The seized articles were kept in the go down on 28/1/2017 at 2:10 hours. Full stop. Exhibit 7 reveals the exit of the seized articles to be produced before the CGM on 29/1/2017. Exhibit 12 reveals, Exhibit 12 is the
Exhibit 12 is the lordship sending of the samples for chemical exam.
Exhibit 12 is the forwarding of the samples for chemical samples drawn for chemical examination. But where were the articles kept after the articles were produced before the CGM? When the NDPS Act mandates that that the articles before being forwarded to the forwarded for forensic examination has to be kept properly, and a proper register has to be maintained. Full stop. After the articles were sent sent for examination by the CGM on 29/1/2017, it is not clear from the evidence of the witnesses as to where the articles were kept and then forwarded for forensic examination on 30/01/2017. There appears to be every possibility of manipulation or mishandling of the articles seized in connection with this case. As there is no clue as to where the articles were kept, the appellant deserves a benefit of doubt. The provisions of section 52A of the Act was not scrupulously followed due to the lack of certificate of the seizure of the articles and the samples drawn by the CGM when the same were produced before the CGM. Okay then? Heard learned counsel Mr.
NH board.
M.H.
NH board.
NH Borbhuya for the appellant. Learned counsel Miss
R. Hussain.
R. Hussain has prayed for adjournment as learned sending counsel Mr. S.C. KL is not well. Full stop. Learned the learned counsel for respondent has also submitted for time to submit a written argument. List the matter on as parted item
At two.
as parted matter. At the on to some other cases fixed. So after that case will
Yes.
Obliged.
এইটো হেৰি এইটো লৈ যাব তাইক দি ভৰাই দিব পৰা আৰ্গুমেণ্টছ জেগাটো
May I please, Your Lordship? This petition has been filed for quashing the charge sheet, which is there at page number 26,
আইটেম নম্বৰ কিমান
7, Lordship.
Okay.
What has happened, Lordship, here in this case, the FIR, when the FIR was lodged, it is at page number 18, the first annexure. This, the incident was of the March 2018. And after a month, the FIR was lodged. I'm just reading the translated portion of the FIR. Annexure 1, page 18, Lordship. Sir, I have the honor to state that the accused persons are tenants at the above address. My brother-in-law, Nikhil Roy, and my another brother-in-law, Nilu Roy, resided tenants at E&D colony such and such. After my son, Deep Kumar Roy, had stayed for some days in the rented house of my brother-in-law from the month of January, brother of husband and Nilu Roy, the younger brother of my husband, went to the house of Srimati Shoma Roy, a tenant in the house of the accused persons, talking along with my son to attend the invitation. The accused persons detained my son and assaulted him on his head and various parts of his body by means of sharp weapon and rod, and thus caused grievous injury to him without any reason. My son became unconscious and the elder brother of my husband and others took him to SMCH and provided treatment to him. Having learnt about the incident, I went to see my son and as his condition was not well, I again took him to SMCH, whereupon doctor referred him to Negrim Hospital, and accordingly I immediately took him to the hospital and provided treatment to him. The lodging of the FIR got delayed as I was busy with the treatment of my son, as the accused person is assured for an amicable settlement. So this is the case, Lordship. There was the delay that has been attributed with regard to the fact that there was an amicable settlement with the accused persons at that point of time. And now what is the status? Status is a tenant. These persons are staying as a tenant in the rented premises of the father of the petitioners. Now what has happened when this incident had happened? The case was registered under section 341, 325 and 34 at the time of registration of the case. Now what has happened at the time of submitting the charge sheet, the section 307 has been added with regard to the, if your lordship kindly see the last page number 27. Page number 27.
Okay.
During investigation, a prima facie case under section 341, 325, 307, 34 IPC has been found when established against the accused persons. The names are there, they are the petitioners. Now, how this 307 has been added in the charge sheet? Because in the FIR, at a bare perusal of the FIR transpires that, lordship, there is no such allegation or there is nothing has been mentioned in the FIR that there was preconceived notion or the preconceived attempt on the part of the petitioner to cause any injury resulting in the death of the victim, lordship. There was no injury, nothing of the sort, nothing has been specified what sort of injury he has sustained. And because of that lodging of the FIR, lordship, after a month, delay of 1 month, the case was registered under section 341, 325 and 34 IPC only. And now these subsequently at the time of submitting the charge sheet, this section 307 has been added. And there is no evidence whatsoever.
An attempt to commit.
Exactly, lordship. There is nothing allegation. I just made a mention with regard to the FIR. Even it has been mentioned that accused persons issued for an amicable settlement. She has waited for a month for the amicable settlement with the petitioners. Now, since no amicable settlement could arrive at between the petitioners or the accused persons with the informant, now she has lodged an FIR. It's a completely, lordship, a got up story to put some sort of pressure upon the petitioners or their fathers. And they are the tenants in the suit premises, the concerned premises, lordship. So this 307, incorporation of 307 in the charge sheet is an afterthought on the part of the prosecution.
What are tenants?
Lordship.
They are the tenants.
Exactly, Lordship. It is there in the mention in the FIR itself, Lordship.
Petitioner is the tenant.
Not the petitioner, Lordship, the victims and the family
Victims.
members of the tenant. And all the witnesses are the relatives. These are all interested parties, Lordship. And amicable settlement could not arrive, and that is the reason why she lodged an FIR. It goes to show their malafide intention on the part of the prosecution to frame the petitioners for some vested reason, Lordship. So there is nothing but abuse of the process of the court, Lordship. At this stage, I'm just praying for stay of the proceeding so far as section 307 is concerned.
My lord, here FIR filed thereafter, my lord, after investigation police has found material, my lord, thereafter charge sheet submitted, my lord. My lord, that is explained, my lord, here. Due to a treatment, my lord.
Amicable settlement.
Amicable settlement.
No, my lord, here, Lordship, first of FIR, my lord. Page 19, my lord.
Yeah.
So and so taking along with my son, attend the invitation, the accused person detained my son and assaulted him on his head and various parts of his body by means of sharp weapons and rod, and that caused previous injury to him without any rhyme or reason. My son became unconscious, and the elder brother of my husband and others took him to SMCH and provided treatment to him. Having learned about the incident, I went to see my son, and as his condition was not well, I again took him to SMCH, whereupon doctor referred him to Negrim Hospital, and accordingly, I immediately took him to the hospital and provided treatment to him. The lodging of Azahar got delayed as I was busy with the treatment of my son, and as the accused person assured for an amicable settlement, my lord. Lordship, if he is not injured, my lord, how he was transferred from one hospital to one hospital, my lord, up to Negrim, my lord. There may be some condition, my lord, that due to the treatment, FIR was delay in lodging the FIR, my lord. But sometimes it was also happened that they are also waiting for a settlement, my lord, perhaps. But that is not the cause, my lord. There is no abuse of the process of the court, my lord. Lordship, here, Lordship may call for, my lord, a notice issue and call for a record, my lord. At this stage, my lord. 307 is there, my lord. His injury is how much injury? It is not here in the from the, my lord, petition, my lord.
See, first of all, you are staying as a tenant, and now you are assaulting your Malik.
Right. And in the, my lord, searching, it was also, my lord, address, my lord, includes page 27. Sketch made of the PO, CT scan report of Deep Kumar Roy, one report from professor and head of the ophthalmology, SMCH Silson.
Ophthalmology. Eyes. The allegation is in the head.
There has to be some grievous injury. 25.
Yes, Lordship, I've seen that. Sketch map of the PO CT scan report of the Deep Kumar, one report from the
CT
professor.
scan report.
CT scan report and one report from the professor and head of the ophthalmology. Now they are asking report from the ophthalmology, and the allegation
One,
is
two,
that
3 is there.
1, 2,
Two
3,
is
I can
CT
understand,
scan.
Lordship. CT scan is there, but the report they are asking from the ophthalmology, not from the doctors related with the any sort of injury in the head.
It reveals from CT scan, my lord. CT scan report is there.
Eye problem and this neurological disorder, any sort of injury in the head. Because the specific allegation is that there is no injury in the eye. Say allegation is injury in the head.
Head, therefore, a CT scan report of Deep Kumar Roy, my lord. That is here, my lord, in the charge sheet, my lord, along with the charge sheet.
And even he was not admitted in the hospital also. There is no medical certificate with regard to that.
So Sashi has been submitted.
My
You are
lord.
on bail.
Lordship?
Are you on bail?
No, Lordship.
Not on bail.
With regard to 307, with regard to other sections, I am on bail. Because that was subsequently added, 307. That's why I am here for the quashing of the FIR, Lordship, the charge sheet. Because the other sections with regard
For bail will not stay. head injury CT scan report, then he has given the report 325. 307 is not there. Sure, it's not there. Because there is no allegation of attempt to murder. But 325,
No, with regard to that 325, 34, I have obtained the bail. But 307, that was subsequently added. That's why I could not apply for the bail. Only thing is that since there is no material with regard to 307, I approach this honorable court for quashing of the charge sheet only with regard to 307.
see, maybe the FIR was lodged after 1 month, but you see, he has sustained injuries, grievous injuries on his head.
On the vital part, my lord.
Or CT scan report is there. But maybe no, there is no allegation of attempt to murder.
Exactly, Lordship. That is our case. There is no allegation, even there is nothing on record which would show that there is any attempt to murder on the part of the petitioners.
So you are the owner of the house.
My father, Lordship.
Your father is the
Yes,
owner of the house.
I'm the son of, and it has been specifically mentioned in the FIR also, Lordship.
Will the tenants beat
No.
will the owner beat the tenants?
No, it's not like that, Lordship. It's a make-out story, Lordship. What has happened, there was some dispute between the parties, and because of that, some sort of scuffle was there. I'm not denying that. But the fact remains that whether in the FIR also it has not been specified that whether there is any attempt on the part of the petitioners to commit murder, Lordship. Nothing like that, Lordship.
No, there is nothing.
Exactly, Lordship. There is nothing. And after a month, that's why I'm saying, Lordship, and I have highlighted that aspect of the matter. There was some negotiation.
I am not worried about 307.
But how he is injured?
But I'm not happy about this section 325. Cannot be stayed. Head
No,
injury.
307. I'm not praying for the 325. With regard to 307 on, Lordship. Because 325, I have already obtained the bail, Lordship.
But if I'll stay,
After perusal of the records, Lordship.
if I'll stay the proceedings, I'll not pass an order for no action, no coercive action to be taken or all this. I'll not pass an order.
With regard to other sections, Lordship.
So then he will have to be he will have to apply for bail.
No,
Why
that
don't you apply for anticipatory bail? You apply for anticipatory bail.
no, Lordship. That at this stage, after submitting the charge sheet, whether I can file an application for anticipatory bail, because
Okay,
charge sheet has already been submitted, Lordship.
Are you shown as absconder?
No, Lordship, I have not
It has
been shown as
charge
responder. I appeared before the concerned IO, Lordship, during the relevant period of time. I participated in the entire process. The questioning was there. Everything was done, Lordship. Subsequently, this section has been added, Lordship. There is no reason at the initial phase, Lordship, and there was no apprehension on my part that this section will be added. And that's why I did not file the.
Anticipatory bail even if charge sheet is submitted. Although you are not shown as absconder, but you can file for anticipatory bail. Because we have granted anticipatory bail in cases where charge sheets have been submitted. Or else you appear before the court and you apply for bail, court will not grant you bail definitely.
Yes, Lordship, the apprehension is there, Lordship. And I am a government.
No, but protection cannot be sought in this matter.
But Lordship, there is no prima facie case. There is no ingredient of section 307, Lordship.
It's true.
At the time of registration, they did not incorporate that section. But at the time of submitting charge sheet, what has happened during this relevant period of
No,
time?
but I'm not willing to stay the proceeding. There's no 307 to come at the point of trial. I'm not willing to stay this proceeding under section 325. Because we have a head injury.
No, then Lordship may at least pass an order with regard to 307, Lordship.
No, why should I pass an order for 307? What type of
Single
order? He'll be protected.
Yeah.
He'll be protected and you won't apply for bail and then this will become a very irregular proceeding.
No, Lordship, at this stage, if your Lordship kindly pass an order, proceeding with regard to originally it was under section, yes.
When I'm not happy about 325, smaller section,
Yes.
how can I pass an order for 307, which is not there? I agree with you. There's no allegation of attempt to commit murder. But I don't want to stay the proceedings so this case under section 325, lower offense. That is what I'm saying.
No, Lordship can at least pass an order with regard to 307 because with regard to other section, I am on bail. With regard to other sections, I am on bail on perusal of the materials available on record, Lordship. Because when subsequently 307 has been incorporated, there is apprehension on the mind of the petitioner because in that point of time, charge sheet has been submitted. So if
It's an order for 307 when I'm unhappy under section 325. 307, I'm keeping it keeping it at bay. I'm not considering 307 at all. 325, this case doesn't deserve stay. We have this report.
Lordship may call for this scan copy of
Offense
the
against body. This is classified as offense against body. Body, you know.
320. Lordship may call for the scan copy.
I'll call. But you see, you won't get any relief from any court. Any court under section 307, you'll have to apply for bail. This is what I am advising you. You'll have to apply for bail. You won't get relief in any court. Nobody will stay these proceedings and grant you relief.
That I can understand, Lordship, but the prima facie when there is a material is not there. Prima
See,
facie absence of yes,
The LCR also
yes, Lordship.
won't be granting stay for 325.
But 307
Maybe
is
some other
yes.
court may grant stay for 325. But 307 is out of question.
Matter of fact.
We are not considering it at all. It may not be a case of 307. He may be acquitted under section 307. We are not considering it at all. But 325, yes. So how can you get protection for a higher section when nobody is satisfied in a lower section? You'll have to, I think you'll have to rack your brains for protection.
Lordship may issue the notice, then I'll take care
Yes, yes. Hard Learner Council, Mr.
of SP Chaudhary, Lordship.
SP Chaudhary, no?
Yes, Lordship.
For the petitioners 1, 2, 3 who have filed this application under section 528 of the BNWS 2023 challenging the for quashing
Yes, Lordship.
the charge sheet for quashing the charge sheet number 1076 of 2023 as the charge sheet has been filed under section 341, 325, 307 by 34 IPC stating that when there are no allegations of attempt to murder, then how would section 307 be incorporated? Issue notice to the respondents, returnable within 2 weeks. 2 weeks.
Lordship.
2 weeks.
2 weeks, Lordship.
2 weeks. Call for the scan copies of the trial court record. Heard Mr. B. Sharma, learner additional PP Assam. Scan copies kolun niki?
Scan copy of trial court record and CD.
Here, scan copies of the trial court records along with the scan copies of the CD.
Well.
List after 2 weeks.
Well.
Do you want a date?
At fixed date may be given, Lordship. I'll take steps.
2 weeks need to play date of the DDA.
19 June. Obliged, Lordship.
Item number 24 order.
Observation to the
My lord, here we have received the case diary, my lord. From the office note also it was service was completed, my lord. Here medical report was called from the medical GMCH, my lord. It was not, my lord. I pay for return the case diary, my lord, for up to date, my lord.
Criminal petition, no?
My lord.
Okay, you want an up-to-date CD?
Up to date CD, my lord, along with the medical report, my lord.
CD is sent without the medical report. Send back the CD is forwarded. Send back the CD. Call for the up-to-date CD with along with the medical legal report.
From GMCH, my lord.
From the GMCS, list the matter. Interim order shall remain in force till the next date.
18 of Bishop to the 25th.
Interim order আছে no?
Interim.
Can give a longer date.
Your Lordship, the engaged counsel is busy in another court. Could you kindly take up the matter after a little while?
After?
A little while. So pass over for a little while.
I can 20.
20. Yes, now.
Okay, after a little while then.
Much obliged.
Your Lordship, in the last occasion, learned PP was being asked to take instruction as to whether the notice has been served. It's a POXO matter for.
Yes. Notice has been served.
My lord, today I have not received any report, my lord. For that may be given, my lord. I will confirm, my lord.
But see, it can be fixed after some time because last occasion also we have waited for 1 week and he is behind the bar, your lordship.
After sample not possible, my lord. It is from IO, my lord. Where is IO, my lord? I have to take.
Learned additional PP, Mr. B. Sharma has submitted for time to obtain instructions if notices have been served to respondent number 2. List the matter, date the video.
Lordship may give a short date because he's behind the bar, your
The video.
next week. Next week. The appeal is still to be considered. Public.
13 seats.
May please your lordship. Lordship, it's a POXO matter.
My lord, as per office note, my lord, service report not received, my lord. It is awaited.
Service report on respondent number 2 is awaited. List the matter on 17 June. We have the LCR.
May it please your lordship. Lordship may have a look at page 17, the FIR matter.
Which one? There we have two items.
Item number 44, if your lordship takes up, Hamid Ali, my lord. 44, item number 44, page 17, my lord. Well, this is an FIR, my lord. The lordship will find the name below, my lord. Name and details of the accused, my lord, Selimuddin and Jamal Ali, my lord. Now, my lord, lordship may turn to page 21, my lord. My lord, my name is there, my lord. This is a forwarding report, my lord. Muhammad Hamid Ali, my lord. Lordship got it, my lord. My lord, I was arrested on 8/10/24 at the top, my lord. My lord, I was arrested on the basis of the, my lords, on the basis of the statement given by those two earlier, my lord, accused, my lord, Selimuddin and Jamal Ali, my lord.
Okay.
Now, my lord, the earlier one, my lord, Selimuddin, the lordship will see, my lord, the lordship had granted bail, my lord, to that Selimuddin, my lord. That Selimuddin lordship had considered his bail application, my lord, on the ground, my lord, that no, my lord, no ground of arrest was provided, my lord. That is, your lordship will find at page 54, my lord. Section 48 was not complied with.
Page 54.
Page 54, my lord. Notice under section 48 BNSS.
Okay. Is the notice to the relatives?
Relative, my lord. That was not provided, my lord. On the same ground, my lord, your lordship had granted bail, my lord, to him, my lord. Now that judgment, that order passed by your lordship, my lord, of my lord Salimuddin, my lord, 14/05/25. There, my lord, paragraph 9, my lord. Scan copies of the trial court record also reveals that notice under section 48 was not issued to the petitioner family members. In light of the decision of the Honorable Supreme Court, in the case of Vihan Kumar Supra, it appears bail has to be granted to the petition. Here, my lord, the same order will prevail, my lord. Only the name, my lord.
Okay.
That much, my lord.
Yes.
And the other case, my lord, 45, my lord, he is appearing, my lord. He had
Similar.
He had asked me, my lord. Well, here, my lord, same, my lord. Selimuddin and my lord, Selimuddin granted bail and he is Jamal Ali. My
Same, no?
Same, my lord, Jamal Ali. My lord.
Oh, he's Jamal Ali.
He is Jamal Ali. My lord.
And for notification you have sent.
Notification annexed course,
Page,
page 30, my lord. page 30. Page 29 and 30.
These are notifications.
Yes, ma'am. The notices, ma'am. I asked. The same, ma'am, parity, ma'am. That much.
Published.
Obliged to take class.
All these two cases are listed day before yesterday in before this court. In that day, actually, some other there are two issues we are raised also. That
Okay.
there are some cases which are wherein on arrested prior to the Pankaj Bansal, and there are some after Pankaj Bansal but before probable proof test. This case was after Bansal before probable proof test. So Lordship has fixed all this matter along with a part as a part hard matter. Lordship along with those matters yesterday, but yesterday this bench was not available.
Okay,
That's
okay, it
why-
was deferred.
That's correct. So Lordship, Lanet senior colleagues part has Lordship heard. So I will make this submission on the day when it is listed.
Here is a parity case, ma'am.
Or any other day Lordship to make any fix it. Because today I am not. My task.
But after Pankaj Bansal and before Probi Pukasta, then I think they will deserve bail, I think.
Yes, my lord. My lord, may I rely upon a coordinate bench, coordinate bench judge?
That was not asserted twice, no? Probi
Because
Pukasta.
also, why I am submitting to the effect also because in Pankaj Bansal case it is stated also that
Prospective effect.
prospective that is one. Another is also
Then we have
written
young
ground of
women,
arrest has to
huh?
be written ground of arrest has to be is declared to be punished. But Probir forecast on the it is stated also that how that written ground of arrest should be. What is the criteria that would be? And thereafter in Bihan Kumar, some more clarification came also.
Yes.
So also these are the clarifications that is the some procedural also how it is to be. But the main thing is that also the written ground is to be given. And to that effect, Lordship, we have already furnished them in section 15 notice written ground of arrest. And as we have furnished that written ground of arrest, even after before Pankaj Bansal and after Pankaj Bansal, and but Probir Purkasta, when there is some guidelines are framed after in Probir Purkasta case, and there are some guidelines framed. So after yes, I have to say also that after Probir Purkasta, those guidelines have to be we have to follow. But also before Probir Purkasta, there is no such guidelines as mentioned now in the Kumar or Probir Purkasta. So whatever notice we have been furnished to them, and some person when persons are caught red-handed. So the actual thing is also Article 22. What does it says? It says also that it is to be informed him so that he can actually he can avail one legal petitions to defend himself. So Lordship, when person do not knows himself that what he is doing, when he is carrying some NDPS substance with him, like so many with commercial quantity, so he knows what he is doing. And so immediately after giving him, furnishing him that ground of arrest, it is not like that he is not, he could not because of that ground of arrest not mentioning, because of not mentioning that particular lines, particular as stated in Probir Purkasta as well as Bihan Kumar, he could not avail, he could not go, he did not know what is the reason, and that is why he did not engage any advocate. That is not like. So he, immediately after punishing him, he also take the counsel for his defense process. Also, section 15 notice itself.
No, but you say they have this 48.
Here,
58.
yes, but here I am arguing on 50A, my lord. Let him.
There it has to be in writing to these relatives also.
Lordship.
58 writing with liability.
In relatives also, according to Rian Kumar's case.
48 from mental.
58 from the other.
58 from grounds. Second request, page 53 to Swatami. Yes. Page 54.
Yes, Lordship. It is also Lordship, yes, it is not mentioned here. But Lordship, Article 22(1) never differentiate to in that article 47 notice, 48 notice. Article 21(1) never.
No, but in Rian Kumar's case, last
Bihan
week,
Kumar's case, Lordship, yes, Lordship. When Bihan Kumar,
those in those cases they have not taken the this plea of section 48. All those cases you have argued, part heard, and they want to reply. They have not taken the plea of, I think they will take it now.
Then article for only because of when 48,
That's why they have
even
taken
there
time.
is no mention about article 48 notice in Pankaj Bansal case also.
No, but in Vihan Kumar,
But in Bihan Kumar, it is there, Lordship. But Lordship, when Pankaj Bansal was holding the field till the date of Bihan Kumar, when Bihan Kumar is not, when Bihan, as it was holding the field, and Pankaj Bansal was never says about 48 notice, then how the Bihan Kumar case will be? And on the other hand, Lordship, I have only on the I have argued on the point of that, Lordship, parent crime and sub-silent because Lordship, as one part is followed, one part
but
ratio has been taken.
yeah, all those people know who were arguing on that point. They were arguing on the point of only this 47 notice, 50 notice.
40
And
notice,
we have-
when 40 is notice prior to Bihan Kumar, where there is any criteria from in Pankaj Bansal case or other Lordship that 40 notice has to be given. What is the main issue comes from
Yeah,
Article
that is
22(1). We
we
cannot.
not have.
We did not.
Only in Vihan Kumar we have.
Then we have to remind it, Lordship, that all these issues have come from Article 22(1). Article 22(1) when comes, Lordship, only the issue is Lordship, where he has to be informed. Subsequently, all these are developing day by day. Today, we cannot say, even Lordship can think, Lordship, when Pankaj Bansal case, there has come, Lordship, that ground of arrest has to be given. Nothing more than that. In Probirpur case, that ground of arrest, reason of arrest differentiated, so he has to be, it is to be mentioned how the ground of arrest has to be mentioned. Come some more clarification. Thereafter, in Bihan Kumar, some more clarification. The language he has to what he has know. So, Lordship, can we say that can now someone will come that after Probirpur case, though we have given him the ground of arrest, but he did not know the English. That is why he is today, because Bihan Kumar has now says that he did not know English. So it is developing, Lordship. And Lordship is well aware about the Kasiruddin. Now it has come, Lordship. It has again stated that only informing him or told it is sufficient. It will be comply with it will be amount to comply Bihan Kumar judgment. So, Lordship, these are all are what I am going to say. That Apex Court has honorable episode has given some citation, given some judgments with placing. But all those are not retrospective in nature, because though it is retrospective, all the judgments which are not mentioned specifically as a prospective, it is retrospective effect of whole. But the ratio we have to see, Lordship, because
But
Lordship,
in this case, I think they have been behind bars for a prolonged period. How many witnesses have been
regarding that
examined?
issue, Lordship,
Not a single witness.
Not a single witness has been examined.
My lord, and so far my learned friend is arguing on the point, my lord, whether it should be retrospective or prospective, my lord. Well, our coordinate bench of this court, my lord, recently, my lord, I have just given the judgment, my lord. It's of my lord. The name is my lord Amir Ali, my lord. Amir Ali, my lord, dated my lord 26/25, my lord. Where, my lord, your lordship will go directly to paragraph 18, my lord. This stand was taken by the prosecution there also, my lord. It says, my lord, paragraph 18, my lord, may I read, my lord? Though in the case of Pankaj Bansal, the word henceforth was used, meaning thereby from the date of pronouncement of the judgment law laid down there would be applicable. And on such account, Honorable Supreme Court had refused to give effect of the same retrospectively in case of Ramkishore Arora Supra. And on such submission, Mr. Borthakur had some force. Yet there is no such direction in case of Vihan Kumar regarding prospective effect on the said decision. That being so, in view of the proposition of law so laid down in the case of Kanik Sinha versus West Bengal, judicial decision are presumed to be retrospective application unless mentioned otherwise. That being so, the court is unable to record the concurrence of the submission of Mr. Borthakur, learned additional public prosecutor. Clearly states, my lord. Now, my lord, the recent judgment of the Apex Court, my lord, in Kashir Reddy, Upendra Reddy, my lord. Here, lordship got the judgment, man.
No.
Lisa. Kashir Reddy to listen. Here, my lord, lordship may go to paragraph 36, my lord. The last page, my lord. Paragraph 36. If a person is arrested on a warrant the ground for reason of arrest is warrant itself. My lord, so far the warrant, my lord, one point I have to say, my lord, just for a moment, my lord. The warrant as per of Guwahati High Court rules, my lord, there is no grounds of arrest. I am not on that, my lord. Anyway, my lord, if a person is arrested on a warrant, the ground for reasons of arrest is the warrant itself. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed the grounds for his arrest. If he is arrested without a warrant, he must be told why he has been arrested. If he is arrested for committing an offense, he must be told that why he has committed a certain offense for which he would be placed on trial. Why he should be placed on trial, my lord. In order to inform him that he had committed a certain offense, he must be told of the act done by him which amounts to the offense. He must be informed of the precise act done by him for which he would be tried. Informing him merely on the law applicable to such acts would not be enough. My lord, here, my lord, the apex court has relied, my lord. Generally, my lord, the apex court, my lord, relied upon a judgment of the High Court. The apex court, rare cases, my lord, relies the judgment of a High Court, my lord. Here, a judgment has been relied, my lord, Bimol Kishore Mehrotra, my lord. This case was reported, my lord, in AIR 1956 Allahabad. That was a judgment passed by a division bench, my lord. So, my lord, in the year 1956, it was held that section Article 21(5) should be 21(2) should be complied with, my lord. In that case, my lord, paragraph 21 and 30, my lord. 21 and 32, my lord. My lord, 32, my lord, it's your lordship pleases, my lord. I have only one book. Can I give, my lord? Paragraph 30 and 32, my lord. Now, my lord,
Okay.
this case, my lord, the case of my recent case,
Then in this case, 2 years he's been behind bars, 2 years.
More than 1 year.
more than 1 year.
Lordship is
deciding the issue on the law incarceration that I leave it to Lordship because Lordship I'm not
How
a.
many years he's behind bars?
No, my lord, within
than
a, 1 year maybe.
More than 1
Near about 1 year.
28, 29, 4.
Not 1 year.
More than 1 year. So 1 year already been in.
Just now, just on air have passed.
Not 1 year.
No.
Not 1
We'll
year.
take this up later. We'll take this up. We'll take it up together with
But
the other.
this is a case of parity, my lord.
29.
Like,
four-
like,
No, parity, there's nothing about parity in heinous offenses.
no, parity means, my lord, your lordship had considered, my lord, one of the baby.
Yes. Sometimes I consider
But
because that was in full swing. Grounds of arrest was going on in full swing.
yes, my lord.
So now we'll take it up together. He has a point.
Regarding, my lord,
Huh?
to point. Regarding
Article 21.
Article 21, yes, my lord. That's why, my lord, I have also relied upon the.
We'll take it up together. All the matters will take it up together. One day. Which day? That way, when are the other matters free?
It was not fixed, Lordship, Lordship. Along with them and by.
When were the other matters fixed? Date fixed for our
Data fixed by the.
I have also to pass orders in four cases that I will pass according to me, but these cases I'll pass according to the arguments at the bar. This won't get completed. It will take some time. Heard Mr. N.J. Dotto, learned counsel for the petitioner, and Mr. F. Hope, learned counsel for the petitioner. 44 or 45, huh?
44 and 45.
List this matter along with the.
Well, this could be heard separately because we are on 48. But that matter, any date. I am not on the date, my lord. Or I'm not on the date, my lord.
Along with BA number 981/25 and others.
And if it gets delayed, then you please get it listed
My lord.
next week. If it gets delayed.
Next week, my lord.
Because I have heard you for the second time.
My lord.
Now I know.
My lord.
I'll keep this with me.
My lord.
I'll keep this.
Yes,
with
yes,
me.
yes, yes, my lord. নালাগে এইটো বেলেগে থাকক দিয়ক
এখন থৈ দিয়া
that judgment may be kept.
I think other matters will be left over. I won't be able to take in. I'm not feeling well really.
Well, I'm okay.
I'm so sorry. I'm not feeling well really.
Oh my lord, no problem.
If you want me to survive till tomorrow, please excuse me for today.
I think 35.
35.
Date may be given.
I think 35.
Within 17th, man.
35. As agreed by both the parties, list the matter on 17th. এইটো হেৰি কৰি আছো ন June. এইটো হেৰি কৰি আছো অফ কৰি